Major breaking news. The United States Court of Appeals for the 8th Circuit out in Missouri and Minnesota and the like has found that 18 to 20-year-old Americans have the right to keep and bear arms in all respects no different than Americans who are over the age of 20. And knocking out Minnesota's ban on 18, 19, and 20-year-olds from being allowed to carry guns in public for self-defense, the 8th Circuit has struck a major blow against America's anti-gun movement in a huge way, and, believe it or not, they have used the Rahimi decision, which I know a lot of people are upset about, but I told you don't be. They used the Rahimi decision as a weapon against the gun control movement, as I predicted. You're not going to want to miss this when we get back. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of the brand new best-selling book, Israel Disarmed, What the 10/7 Terrorist Attacks Teach Americans About the Right to Bear Arms. Check it out. A lot of great international and historical data and information about the importance of armed citizens, the right to bear arms, and the like. Check it out on Amazon, Israel Disarmed. All right, folks, so huge win today. Huge win by the United States Court of Appeals for the 8th Circuit, ruling in favor of a case brought or supported by the Second Amendment Foundation and the Firearms Policy Coalition. I think the NRA also played a role, among other groups. The case name is Kristen Worth versus Jacobson. You may recall there is a statutory law out there in Minnesota that says 18, 19, and 20-year-olds are not allowed to get a concealed carry permit, thus they cannot carry handguns in public for self-defense. There is a lawsuit brought challenging this on Second Amendment grounds, saying that 18, 19, and 20-year-olds are indeed part of the people, as in the text of the Second Amendment reads, of course, the right of the people to keep and bear arms shall not be infringed. And of course, 18, 19, and 20-year-olds are part of the people. The anti-gunners say they're not part of the people, and that was ruled again. The anti-gunners lost in this case. We'll break it down in 1 second. And essentially, this is a very big win for several reasons. So to begin with, this court uses the Rahimi case by the U.S. Supreme Court, which found that Rahimi, who was on that record, a violent guy, that he could be disarmed under the Second Amendment temporarily because he was shown to be violent in court. But it said a lot of other favorable things. And one of the things it said was, even if you have, and this is very interesting, listen carefully, it's a one-way ratchet in many respects. Even if you had restrictions on certain people, or at the time of the founding, certain things could be banned or restricted in terms of the right to keep and bear arms. But if things have changed in favor of freedom between the 18th century and today, then the Second Amendment will recognize those additional freedoms. It's a one-way ratchet toward freedom. Specifically, the court writes that Minnesota, who's on the other side, they're on the gun control side, Minnesota asserts that because 18 to 20-year-olds did not possess all their political and civil rights at the time of the founding, they were viewed as minors, arguably, at the time of the founding. Today, they cannot be considered part of the political community because the Supreme Court in Heller said that people, as in the right of the people to keep and bear arms, shall not be infringed. The people are all members of the political community, national community, basically, which includes all American citizens. Minnesota says because at the time of the founding, there's arguments and evidence that 18, 19, and 20-year-olds were not full members of the community because they couldn't vote and whatnot. They could be disarmed. But this court, the 8th Circuit, in a very powerful decision, said that that is borderline frivolous. In the same way that at the time of the founding, there could, in theory, be restrictions on handguns because they weren't that popular at the time, or relatively unpopular at the time of the founding, allegedly. But then they became ubiquitous and very popular today, and now they're protected under Heller. So the 8th Circuit says, citing to Rahimi and Heller, that look, even if we assume that 18, 19, and 20-year-olds in the 18th century were minors and not full-blown political adults, that's not how we're going to measure who's in the national community today in the 21st century. Today, because of constitutional amendments and changes in society, 18, 19, and 20-year-olds are full-blown political actors. They can enter into contracts today. They can get married today. They can change their genders today. I don't think the court said that, but you get the point. They can have abortions, of course, right? And they have the right to vote and all these other things. So therefore, even though at the time maybe 18, 19, and 20-year-olds didn't have those rights, but today they do, and therefore today they are part of the national community today, and thus they have the right to keep and bear arms. They're certainly part of the people that have the right to keep and bear arms. Then, of course, there's analysis of the historical analogs, which we'll get to in 1 minute. Here's what the court wrote. Heller rejected the idea that the Second Amendment protected only the original contents of the defined term arms and instead applied that original definition to all instruments that constitute bearable arms, even those that were not in existence at the time of the founding. And then, of course, in Heller, they found that modern-day handguns are protected arms, even though they didn't exist at the time of the founding. So, too, the court goes on to say that the political community's definition today has been expanded. Since the founding, the guarantee of political rights has constitutionally expanded, especially in the right to vote. And they cite to a bunch of constitutional amendments. So the point being that where there's a one-way ratchet toward freedom, things that arguably could have been constitutional in the 18th century could be still unconstitutional today, such as maybe you could have restricted the right to keep and bear arms for 18-year-olds in 1791 for the sake of argument. But even if that were true, hypothetically, you can't do it anymore because they're now part of the national community and thus part of the people. Very big decision, and they rely in some ways on the rationale of Rahimi, because remember, Rahimi has that language here that says that the law is not, set in amber. The anti-gunners think that's good for them. It's actually going to be bad for them. And this is an example of why I say that, because that reference is not about restricting rights. It's about expanding rights to say that there's certain rights that can be protected today that might not have been protected in the 18th century. And that's where that reference to amber comes from. The anti-gunners were all excited about that. And I said, that's not going to work out the way they think it's going to work out. And this illustrates my point that the anti-gunner line, they thought they won in Rahimi by saying that law is not set in amber. Guess what? Has just been used against the anti-gunners to knock out a gun control law in Minnesota. Then the court goes on. Remember how I teach you about the island hopping, that in order to destroy Tokyo in World War II, you can't just fly to Tokyo and blow it all up on day one? It's not physically possible to invade Japan and take over the country on day one of World War II. You have to do island hopping. You have to go to Iwo Jima, Okinawa, and so on. That also works that's how the way to think about constitutional litigation works. We have to island hop, which means we have to create precedent after precedent after precedent in our favor and ultimately get where we need to be, which I think we're slowly but surely getting there. I'm not saying I love the speed, but we are accomplishing the mission. For example, here is an example of island hopping. So the 8th Circuit Court of Appeals in Minnesota relies on the Laura case out of Pennsylvania, a decision by the 3rd Circuit in New Jersey, Pennsylvania, and Delaware that says that 18 to 20-year-olds are among the people for constitutional rights such as the right to bear arms. So what does the 8th Circuit do today? They cite to the Laura case by the 3rd Circuit. You see how those precedents, those bricks in the wall, if you will, keep building up. So the 3rd Circuit decides the Laura case. It says the Pennsylvania law that restricts 18, 19, and 20-year-olds from being able to carry in certain situations, like in emergencies, that precedent that knocked out that law in Pennsylvania by the 3rd Circuit now gets used today by the 8th Circuit. So the 8th Circuit is now relying on the 3rd Circuit favorable Second Amendment precedent. Do you see how that works? And why, when I write in my headlines, this is huge news or this is big news, and some people don't understand why, it's because I can see down the chessboard. I see where these trends are going. And right now the trend is our friend when it comes to the Second Amendment. And I know we have a lot more work to do, but keep the hope going. This is an example of how I covered the Laura case several months ago, and now it comes back and helps us in Minnesota in the 8th Circuit. The next thing happens here in the Worth case by the 8th Circuit is they rely on, guess what, Rahimi again. Remember, a lot of people said Rahimi's terrible for the Second Amendment, and I'm like, yeah, not. Wait, it's going to be fine. Guess what? Well, Minnesota made the argument that says that they can disarm irresponsible people, and they cite to all this language. Guess what? The 8th Circuit quotes Rahimi again to knock out that gun control law. They say, quote, we reject the government's contention that Rahimi may be disarmed simply because he is not responsible. Again, they're saying that that merely showing, if you can, hypothetically speaking, 18, 19, 20-year-olds are somehow not responsible enough to have guns, that's not an argument for disarming them under the Second Amendment. And they rely on the Rahimi case, which so many people said was terrible for the Second Amendment. Of course, obviously, that's not true, as we just saw here in several examples of the 8th Circuit relying on Rahimi to knock out gun control laws, as well they should. And the last point I want to make, there's a lot more here. I'm going to put a link to it down below. You can check it out for yourself. It's a very good opinion. They then talk about whether or not you can even have a law that subjugates people and restricts their constitutional rights, and the court rejected that. The court writes, quote, a legislature's ability to deem a category of people dangerous based only on belief only on belief, would subjugate the right to bear arms in public for self-defense to a second-class right. And they cite to both Bruin and they cite to Rahimi, saying that, again, if you want to disarm somebody, there has to be an individualized finding that says that Bob over there is a credible threat to a third party. And we make that finding after a hearing with due process in court. And here, the Eighth Circuit says, yeah, legislature just can't wave a wand and say, oh, well, everyone that wears blue shirts is a danger, or everyone that wears a MAGA hat's a danger. They're like, no. It has to be an individualized determination, as we saw in Rahimi. Again, Rahimi coming to the rescue for the Second Amendment, which is exactly what I told you. A lot of people were upset about Rahimi. I told you, do not listen to that noise. It's not accurate. Do not stress. Do not buy the hype. Ignore it. If anyone's disagreeing with Mark, don't worry about it. You can assume Mark's probably right on these sorts of things. And here's an example of why I say this. So when I say don't stress, you should not stress. Okay. With that said, another big win here for the Second Amendment using Rahimi by the Eighth Circuit to knock out this law using this kind of language. I want to make one more point about schools and guns because there's some great language in here that's very favorable to us. Remember how I told you that schools at the time of the founding were not gun-free zones? Schools at the time of the founding were not gun-free zones. They were gun-free zones only to the extent, in some instances, the students could be disarmed. But the reason why those students could be disarmed on college campuses like at the University of Virginia was because the faculty functioned in loco parentis, meaning as the parent of these young kids, because at the time of the founding, most of the college kids were like 14, 15, 16 years of age. They were children, really. Alexander Hamilton, I think, was 15 years of age when he started school at what is today Columbia University, the King's College. So the point being that here, the anti-gunners tried to say that there were these restrictions on students in college at the time of the founding, and that justified banning 18, 19, and 20-year-olds from having guns today. But the Eighth Circuit came back and did a great job saying, no, that's not true. They specifically deal with in loco parentis, as I taught you many, many months ago. Here is what they write about why the in loco parentis argument distinguishes those gun restrictions from at the time of the founding from today's gun control laws. This is what the Eighth Circuit writes. They say they're talking about college rules restricting students from possessing guns on campus. That's what they're talking about, okay? They write this, quote, "These rules are very different in their how. These school procedural rules are not laws subject to constitutional limitations. Minnesota acknowledges that universities at the time of the founding, universities had guardianship authority in loco parentis." You hear what I just said? Minnesota acknowledges that universities had guardianship authority in loco parentis. Universities had many practices that, if compelled by the government, would have violated students' constitutional rights. And they cite to a series of these. But then it goes on and draws the conclusion that we've talked about on this channel repeatedly. Thus, founding era college rules are not persuasive authorities to discern the constitutional rights of its students. Bang. Again, as I've taught you, in loco parentis does not exist today on college campuses, for example. Harvard and Yale, they are not the parents of the students at those universities. Those kids, those students at those universities are full-blown adults. And there is no in loco parentis relationship between the faculty at a school, at a university, and the students today. There may have been in the 18th century, but they're not today. And either way, the court here is saying that college restrictions at the time of the founding, to the extent they existed about the students, have no bearing on anybody else. Because remember, even if you could restrict guns for the students at the time of the founding, that was no restriction on ordinary people, the faculty, the staff, the public. It only applied to the students because of the in loco parentis relationship between the school and the students, i.e. they were the parent and they were the kids and you had children, so you were treating them like children. But that was not the case for anybody else in the world. The schools didn't restrict those rights. And again, it's just simply distinguishable from modern day America and the Eighth Circuit saying that 18, 19, and 20-year-olds have full-blown rights under the Second Amendment, and there's no historical analog suggesting that they don't. Major win, Eighth Circuit Court of Appeals. This is just the highlights. There's other things you want to check out in the opinion. Congratulations to the Second Amendment Foundation, to the Minnesota Gun Owners Caucus, and to the Firearms Policy Coalition, and to the other plaintiffs in the case. Major win, Worth versus Jacobson. So there you have it. We'll keep reporting on this. If it goes to the Supreme Court or something happens, I don't know what's going to happen. This will be very interesting to see if the anti-gunners decide to seek cert in this case, or are they going to run away like school children, and hide in the corners and not seek cert because they're scared they're going to lose in the U.S. Supreme Court? So this will be a big test of just how macho the gun control movement is in America. Will they run away, or will they seek cert to the Supreme Court and try to win this case before the United States Supreme Court? Be very curious to see if the state of Minnesota and the anti-gunners seek cert in this case, or again, run away like schoolgirls, run away like school kids. I don't know. We'll see. Be very interesting. All right, folks, make sure you subscribe. 4 Boxes Diner. Don't forget to follow me on X. I have 17,000 followers or so. Check it out at 4 Boxes Diner. Yes, Fox News again today. You probably saw me. Well, it's going to be a busy year talking about Donald Trump and the like this presidential season. Okay, folks, we'll talk to you again soon here at the 4 Boxes Diner.
Orders up. Table 2A.